They're human rights lawyers. And the question is, what does that mean? Does it mean that if there's someone tortured, that they will, no matter what, say that that's the case we have to do? It doesn't mean that. Sure, that's a human rights violation, but I think I look at human rights in a context of what's really happening in this situation, who's oppressing who, and certainly my goal is to try and defend the weak party.
You have to love justice.
So we've come to the end of a long day, a very inspiring one as far as I'm concerned. I've learned a lot today. It's been absolutely fascinating to listen to the many stories, the many memories, and the many good ideas about how to move forward. So now we're coming to an end panel, and it is really a privilege to sit here. My name is Lotte Leicht, by the way. I'm on the board of the European Center. I've been there from the beginning. It started also as an idea when I talked to Wolfgang and to Michael after having lost a case. So, which one? Well, we tried to go after 12 people in Uzbekistan for torture, indefinite detention, disappearances, and other nice things. And we had a very good case, but the German authorities, they actually helped one of the people who were here escaping arrest. And in that sense, we lost. But we won, at least in, I think, the court of public opinion. In any event, it is really a privilege to be here, and I just quickly wanted to introduce the panelists. Two of them I don't have to really introduce because they've already been with us this morning. Wolfgang, it's good to have you back. And Jules, also welcome back to the panel. But we have two new panelists here that you haven't met already, and the first one is Catherine Franke. Welcome, Catherine. Catherine is a professor of law at Columbia, and she's also directing or directs the Center for Gender and Sexuality Law. And she's, of course, also involved with the Center for Constitutional Rights. Welcome. And the second new panelist here is Colin. Colin Gonzalez, who is also a companion at the board of the European Center. And Colin is also the director of the Human Rights Law Network in India. And you're also a senior litigator, particularly on important public interest cases in India. And Colin is having sort of a hidden and a very public agenda here also in trying to establish a pendant to the centers in Asia. And I think we should all be supportive and find ways of helping you succeed in that goal, because it sounds fascinating and important. Now, before we start the discussion, and then I'm not going to talk at all, I'm leaving that to the excellent panelists here. I think after having heard all the inspiring stories, we're sort of at a point now in time where we are seeing the backlashes to all the successes that we have had, both as litigators but also as movements. And I see those backlashes happening from those in power as a result of those successes. So in an odd way, we are talking about an awkward complement, because it matters what we do. And for that reason, those in power are seeing it necessary to crack down on movements, to silence them, to prevent them from both expressing, gathering, and assembling in their countries and make a difference. We're seeing crackdowns on the movements. We're seeing crackdowns on those who write about their work, namely the journalists. And in a sort of in a final part of the crackdown, we're now seeing a real crackdown against the litigators and the lawyers representing them. Many lawyers are finding themselves in jail this time simply for doing their jobs. We're also seeing a backlash against the very law that we see also as vehicles for change, including international law. I mean, the Bush administration attacked international law. It was pretty honest about violating the obligations in the war on terror, but it blamed the law. It said the law was old-fashioned, didn't sort of match today's challenges. We're seeing African leaders now challenging the International Criminal Court because suddenly the court started working and it mattered to victims. And victims brought evidence and cases, and suddenly people were subject to arrest warrants, people in power. So from being a nice idea, this institution, the International Criminal Court, became a real threat to power, and then it was attacked. And here in Europe, we're seeing now not just fringe movements, but actually mainstream politics attacking refugee laws, both at home, but also the international concept of the Refugee Convention. Why? Because suddenly it applies to European behavior. And suddenly it applies to our obligations to protect people on our soil. So the backlash is there, and that is where we are. And what I would like to hear from the panelists is really, how do you see us fighting back? What can we learn from everything we have heard today, from your personal stories and journeys, on moving on and maybe even doing it in new and innovative ways? And I want to give first the floor to you, Colin, also because I think we are sort of missing maybe a perspective from Asia to begin with, and that would be very interesting to hear from you, how you see the situation and the state of play, but also how we meet those new challenges. I think you get your own mic. You should just talk.
My name is Colin Gonzalez from the Human Rights Law Network, India. And I want to give you a slightly different perspective on how to take advantage of the space for litigation, campaigns, advocacy on human rights issues. India sounds like a democratic country, and to an outsider it looks like a democratic country with parliament, newspapers, a free press, and parliament, and so on. But it is a country which is a conflict zone, with 1/3 of the administrative districts under significant levels of armed struggle. Our lawyers live in this conflict zone. We've lived in that now for at least 15 years. And for us, it is a normal state of affairs to live in a country where lawyers are executed. We had a very prominent lawyer, Jaswant Singh Kalra from the Punjab, who, when he exposed the disappearances in the Punjab, several hundred disappearances, he was, when he returned to India after speaking in the Canadian Parliament, he was executed on his return by the police forces. We have a very prominent lawyer from Kashmir, Jalil Andrabi, who again was taken from his house in front of his wife and children, and his body was found floating in the Jhelum River. So we live in a situation where lawyers are under pressure all the time. Many of them are tortured, many of them are in jail. Right to information activists, 15 have been executed in the last 2 years by persons who come up to their doorsteps and shoot them in the head. And it's a normal state of affairs. So we are not unused to violence of a very extreme nature. And you must understand India as a country with great discrimination and great violence. The largest democracy in the world, tethering on the brink of dictatorship and fascism, with a prime minister who is openly an admirer of Hitler, and his party is an admirer of Mussolini, Franco, and so on. Now, I'd like to say, first of all, that I pride myself on knowing what happens in America and in Europe. I travel a little bit, thanks to Wolfgang. I've come for 3 of your meetings, and I've learned enormously. And I thought I knew everything about the Center for Constitutional Rights and what they did in America on Guantanamo Bay and so on. And I must say the morning session blew my mind, because I heard stories and I heard details of things that I thought I knew, but I had really understood it very superficially. And I'm saying this for this reason, that if I, a person who travels and who sort of understands and who lectures in some places abroad, if I can know so little about what you've done in the Center for Constitutional Rights, and know so little of what's happening, say, in Europe on litigation strategies and so on, and cases, you can understand what the situation in my country is. There are hundreds of extraordinary lawyers working under duress, working with great danger to their lives, working on a hand-to-mouth basis, really. Great intellectuals, great lawyers. who never understand, who never get a chance to see this thing. And I would say a few people who held the morning session, the 4 of you, and the session that came in the afternoon, you must come to the developing world. You must come and you must tell these stories there. Because our countries that face armed struggle and so on, we have thousands of Che Guevaras, legal Che Guevaras, right? Fascinating young people. You'd wonder how they manage to survive, but with an intense desire to change the world that they live in. And you must come. You have a duty to come there. I'm not asking you. I'm telling you, you must come to the developing world, to tiny little Nepal where heroic legal struggles have taken place, to Pakistan where under Musharraf and later on, heroic struggles took place against the military regime. You must come, you must tell your stories, and you must enrich the legal jurisprudence of these countries with what you know. That's one. But there's a second part. Much of American and European jurisprudence is a little insular. And much of the constitutional law developments that have taken place in Africa, South America, and Asia remains outside the discourse. And very often, persons from developing countries sort of are forced, straitjacketed into a European and American perspective in terms of the UN system or in terms of the Alien Torts Claims Act and so on. But there's another side that you must understand. You must go to these countries to first of all understand what they're doing. They're doing some crazy litigation with extraordinary results by a system called public interest law, which I'll indicate briefly, but they're doing extraordinary work. And if you go there and you start, if you step back a bit, you all are good lawyers in your own countries, but you step back a bit and you sort of try and understand what are the African lawyers doing, what are the Asian lawyers doing, what are people doing in South America, in the Inter-American Commission, in the courts, in their so it's a large body of constitution law, where the constitutions of these countries are somewhat similar. The principles are the same, the practices are very similar. And you must try and document and understand the marvelous revolutionary work done in countries with constitutions. And when you do that, stop me when you do that, you must enrich their jurisprudence with your case law and your studies and your understanding, because the world is very receptive to the law of developed countries, to European law, to American law. As young lawyers in India, we started with American law. Secularism, the Ten Commandment case, the free speech cases, torture. Can you imagine? We used to follow American law in the earlier period. Now we don't have so much respect for the American Supreme Court as we had when we were young people. But you have a very important role to play in enriching the jurisprudence of that period. Please understand, the poorer you are, the more destitute you are, the more precarious your lives are, the wider is your thirst for global knowledge. Remember that. In India and the developing world, you come as an American professor or as a European professor or a lawyer, and you say, this is my case law. As you said today, this is what we did on Guantanamo Bay, this is our case law on freedom of speech and so on. You'd find a very, very thirsty audience ready to listen to what you have to say and use it in their judgments. We use international law all the time. If you look at Indian judgments, there's reference to American judgments, European court judgments, all the time. We are truly, although we are a very backward country in many ways, we are truly, the developing world and the lawyers there are truly a globalized body of lawyers who think globally and who want to act globally. I have many things to say, but I'll say that later.
You have more chances. Thank you so much, Colin. I think at the same time you managed to give a very bleak and a very inspiring picture. So thank you for doing that. Catherine, I hope that you will be able to also bring into this debate maybe an aspect that has been somewhat missing. It was really part of the last panel now, or Vince's sort of contribution. But I would say really the particular gender aspects, but also sexual orientation developments that we have had in terms of litigation and law, but also the particular challenges that we're facing. If you could speak a little bit more about those. I think that would enrich our
happy
discussion
to.
further.
I'm happy to. I thank you so much for including me in this panel, and to Wolfgang and all of you, and Claire, for organizing such an amazing day. Last time I was in Berlin was 1983. It seems like things have changed just a little bit.
A couple of days ago.
If you'll let me out of the building, I'll go see it. I have a reputation in the United States as being a party pooper when it comes to gay rights. I've written a book called Wedlock and the Perils of Marriage Equality. And some of the lessons I think we can learn from the gay rights movement internationally, but also from the women's rights movement, and I'm going to talk in a second about domestic violence and human trafficking, is that often we can have, contrary to, or flipping Jules's wonderful term, we can have victories without success. We can have legal victories that are, in a way, a setback for larger progressive social movements. And I think that's can happen in three ways that I'll try to go over very quickly. First is where you've got lawyers working unattached to a social movement. They pick off legal issues that are important civil rights or human rights issues, but they're not working with a larger coalition of people who care about progressive change. The same-sex marriage movement in the United States, to me, is the best example of that. There was a broad coalition of people thinking about family in a broad way in the 70s, in the 80s. As a feminist, we had a very thick critique of the institution of marriage. It had never been a great place for women. It essentially is a form of property and ownership, and a way to transfer property intergenerationally. And a few white, wealthy, gay male lawyers took over the movement and said, we're going to pursue a marriage strategy because it's the one thing we don't have. It's the one thing we don't have and we want. And there were terrible fights in the nonprofits in the U.S. between the feminists, mostly women, although not only, and a few guys who were not the least bit feminist, and the men won and pursued this campaign to gain marriage rights. 10 years ago, I would have said, you're crazy. We would get marriage rights for same-sex couples, but we did. And part of why it was a successful strategy is that it was an incredibly conservative strategy. It appealed to very traditional values. There was no aim to upend the institution of marriage. I'm still working on that, and as I know, I'm sure many of you are. But more, it was an assimilationist movement, led by lawyers without any connection to a larger, or actually by disavowing a larger, more progressive social movement. So we had victory with the Obergefell decision in the Supreme Court, which I think was not a success. And you can read my book and learn about why I think that's true. The second way I think we sometimes see victory without success in this area is when victories become co-opted by the state. The state becomes partners in our projects. We often hear the term pinkwashing. Corporations, the state, other powerful entities take on human rights claims, human rights causes as their own in order to improve their reputation, their market share, their power in the case of the state. So the anti-trafficking, human trafficking international movement, after the adoption of the Palermo Protocol, as a criminal justice problem rather than a labor and migration and human rights and public health problem, ended up creating a set of human rights for trafficked people in a way that has reinforced what, at least in the United States context, but I think globally, what we, I think cynically describe as the global war on terror. And it's become an extension of the United States State Department's diplomatic and war-making infrastructure. So too, if we look at domestic violence, I just have been talking to Rima Hamami, who's a professor at Birzeit University in Palestine, in the West Bank. And she's very critical, as are many feminists in the West Bank, with UN Women, with NGOs that have dumped tons of money in the West Bank in order to document, to come in and save Palestinian women from Palestinian men, and document the domestic violence that they live with. And it is true There is domestic violence in Palestine, as there is in every society. But what they've accomplished by lifting up the problem of domestic violence in that context is creating an alibi for sovereign violence, for the violence of the Israeli state. What it's done is domesticated, turned to the home of the Palestinian family as the real source and most troubling source of violence in the West Bank, rather than the violence of the occupation itself and the denial of sovereignty rights of Palestinians. So there's an ecology of violence that it gets lost, gets ignored when we focus on domestic violence in that context. And then the last thing I want to say about victory without success is that what we often do is invest, is through a kind of channeling effect, in the kinds of things that law can deliver. We invest in those things because they're concrete. We have lawyers who know how to do practical things, go to court, go to tribunals. We have very specific tactics as lawyers, and we tend to generate desires within some social movements for the sorts of things that law can deliver, because we're confronting power in a particularly successful way in many contexts. But of course, law can't deliver everything. Actually, law can deliver, and litigation can deliver, a very narrow set of things. And so we see in some contexts the investments that communities put in what law can get them, or in the kind of frame that law brings to understanding the problem, the wrong that's at stake, I think is often short-sighted and can often be counterproductive to the longer-term interests of peoples who live, let's say, for instance, under occupation in the West Bank and Gaza and in East Jerusalem. So the frame of the occupation itself is a legal frame, right? It's based in international law. And so many people living under occupation or living under rule by the Israelis day in and day out with that kind of violence look to the terms of occupation and the law of occupation and what it can get them, rather than alternative forms of resistance or ways to articulate the violence of Israeli rule that would be outside of the frame of occupation and may be a better route to sovereignty, whatever that might look like, whether it's a state or not, than remaining within the terms of occupation itself. So I think there's three different ways where we can see victory without success. That is the challenge of being critical lawyers who are connected to social, progressive social movements, and who are not clergy of the law itself. And I actually have heard that somewhat today, is this almost unabiding faith in law as the primary and best tool to take on power. Law is a form of power. So let's not mistake that there's power here and law is its challenge. Law is a form of power. And it can be deployed by states, human rights can, in ways that can be very dangerous for the people in whose name those rights are articulated. So let's understand in a kind of circulatory way the way that rights and law can be a state project, can be used to oppress people, and as thoughtful lawyers, examine the kinds of ways we decide to use law as a tactic in a larger, much more complicated strategy for accomplishing progressive social change.
Thank you very much, Catherine. I think you brought sort of also new aspects to our discussion here. And I'll go to you, Wolfgang, because the European Center is also soon turning 10 years old. I mean, it's
Not still.
no, but it's close, huh? And that means that you can now look back at quite some experience also that is in a certain way very new in Europe, outside maybe the UK in terms of litigation. What does it tell you about how far we have come, and how much does litigators also in Europe need movements to work with and to build sort of on in terms of affecting change and advancing protection?
So our starting point is what Colin said: think globally and act globally. So we're carrying out transnational litigation, which is, significantly different than, for example, litigation in the context of the. Jetzt war gerade nicht an. So it was very interesting to listen to Vince, but the kind of cases we bring are different. The tools we're using are different. And so it was for us, it was very important to have Colin and people like him on our board as cooperation partners, because they helped us to develop a holistic view. And so here we meet Catherine. It's like we learned our lessons from Jules' book, of course, but I think it's now, for us, it's necessary to overcome this winning-losing paradigm, because it's still too much focused on the action in the court and on the impact in the court. And it was a good example when I heard Reed and Jules discussing, and I heard Reed talking about the only successes were Pinochet and Habre. And I was thinking of whole Latin America. I mean, the universal jurisdiction, starting with Pinochet and later on, led to immense successes together with the Inter-American Court of Human Rights judgments in Latin America. Not only Chile, but Argentina, a wave of 500 judgments against the dictatorship crimes. So never ever was such a wave of national prosecutions possible, but also Peru, Uruguay. We had a lot of judgments impulsed by, let's say, foreign or other fora. And so that is a kind of inspiration for us, what transnational litigation can have an impact. But, of course, we try to discuss with the Collins. And so, or pesticide, use of pesticide exported by companies from Europe. So or we go to India and support domestic litigation there, and or we go to Europe and sue European companies there. And it has, I think it's important to have this reference to social movements, but it's also a little bit of a killer argument. You know, like paying lip reference to social movement and to victims, and I would rather propose, the term of intervention and the term of impact. So we want to have impact, and we have to define the impact of our work, and that maybe in the cases Miriam talked about, the Nestle case, trade unionists in Colombia killed. So the impact may happen in Colombia, but it also may happen in Switzerland, where we litigated. We litigated the first case against a corporation for such a crime. And so the measure is not necessary to have a social movement, but it's necessary to spell out, rather than to have these killer slogans who kind of relieve us from spelling out what is the impact. I think we have to undertake a political assessment. We have to be more and explicitly political, and we have to argue if the investment in law is worth it, because we have little resources. And that brings me to your most important point, because you were saying that times are changing. They are changed in two different ways since 1998, the Pinochet case. So first of all, transnational litigation, transnational coalitions to litigate are possible right now. So that's really and please don't underestimate it. I mean, Miriam and us going to Pakistan and to litigate a case of burned factory workers at the same time in Pakistan, in Italy, in Germany, that was not possible 10, 15, 20 years ago. And I think this is something. This is really an achievement. Oh, sorry, is it? Okay. Yeah. So that is really an achievement. On the other hand, we see that, as you said, the other side know to react right now. We saw it with the Alien Tort Claims Act, where cohorts of corporate lawyers try to counter our efforts. We see it at the ICC, and we see countries like the UK, for example, right now. Theresa May on the Conservative Convention saying we have to stop the leftist law firms to damage the reputation of the British Army. She is talking about us bringing torture cases in the UK with our UK colleagues, who had to close down their office. Phil Shiner and public interest law in Birmingham had to shut down their office. And we're talking about the ICC. So when the ICC case moves on, we are in the danger that they drop out of the ICC statute. So that is something I think we have to learn from this experience, and we are not that far with that, because I think human rights movement tends to repeat. We apply for funding, we get funding for cases and for sets of cases which had been successful in the past, and then we are obliged to carry out the same kind of cases for the near future without thinking if this makes political sense. And I think that's a real danger. We have to be more flexible, more political, more resilient to current challenges.
Jules, now you have to sort of summarize all of this from your perspective. I mean, what are the core challenges going forward? You already enlightened us on some of the lessons learned, but from your point of view and from a U.S. sort of perspective, where do we go from here?
Summarize is a tall order. I'll react. First to Wolfgang, the point of my book was to look at success or defeat in terms of what actually happens in court, and the result in court is missing the picture. And I totally agree with Wolfgang. The key is to look at the broad impact. And the impact could be on movements. The impact is on maybe often on things that you don't even realize. I brought a war powers case challenging the first Bush the first, going to war in Iraq. And 3 years later, and we lost in court. I mean, it's unclear whether we lost in court, but we didn't get an injunction. And 3 years later, I had 2 Japanese students in my class, and they said, we read about that case in the newspaper in Japan, and we brought a case in Japan based on what you had done. And I had no idea that that was the case. So the impact is something that's much broader than we even realize sometimes. Second, on Catherine's point, I think it's a great one. And I actually wrote an article called Victory Without Success, ? And it was about Guantanamo. Because Michael, as great a victory as it was, and both Michael and I and everybody at the center is probably the most proud of the Guantanamo case than anything we've done. Michael gave interviews and believed that in a way it was a defeat. Because our broad point that we wanted to make was that this shouldn't be all done on a war model. That what had been shifted is that the fight against terrorism had been a criminal justice issue. And now it was going to be indefinite detention, war model, prisoners, combatants, and all of that. And on that basic issue, we lost. And he viewed that Guantanamo, in a way, was both a great victory and a great loss. And so I think we have to take Catherine's view and begin to look at the broader implications and what happens with our cases. And even when we win in court, we can lose in the longer run in terms of what we really want in terms of change in society. And so these cases are contradictory. They were a great victory in that they helped, the Guantanamo case, helped create and spur a movement and gave hope to people and resulted in hundreds of people getting released. It was a defeat in the sense that we didn't really fundamentally get what we wanted out of the courtroom battle, which was a change in the whole approach, the military approach to terrorism. And so we've got to keep on struggling on that. It doesn't mean we see this case as a defeat. It just means that the struggle continues. Third, quickly, I wanted to reflect on Vince's talk, because one of the key things I thought about what Vince said was this relief that they got in terms of, on the stop and frisk case, that the community was involved in the relief. And usually in courtroom battles, the court issues an injunction and says, this is what you got to do. But here the relief was bring the community in, bring the clients, bring the people who have been disenfranchised into the struggle and into the change. And in our solitary confinement case, that's exactly what we tried to do. Not just simply substantively change the law so that they couldn't use solitary confinement or restrict it, but that for the first time, as part of our monitoring, and it's the same thing that we have in the Pelican Bay in the solitary case, that we have 2 years of monitoring, like what they have monitoring in the stop and frisk case. The prison officials have to meet not with us, but with the prisoners. And they hated this. And to this day, they hate it. And there's going to be another meeting in a month. And they don't want to do it. But it developed, it created a different relationship between the prisoners and between the prison officials. And it's changing that kind of relationship between the community and the officials, between the prison guards and the prisoners. That is a radical perspective on the law, and that's what we're about. And the last point I wanted to make is I was inspired by what you said, and I actually have a question. I was going to say, I'm not going to say anything, but I'm incapable of that. So I have a question, which is I'd like you to give us an example of the type of inspiring case that you folks have brought in India, and what you think the lessons are for us, and what you think you could learn from us in terms of this type of case. So that's...
What I intend to do is give you four rapid fire cases.
Okay.
Give you the end result. Give you the end result. Tell you the principles on which that end result was based, and really advocate for a kind of global human rights law perspective, where we build an organization like Lawyers Beyond Borders, where we take one huge body of law, which is European, developed country law, American law, which is of a particular kind with particular limitations, and an inbuilt pessimism, if you like, and then look at the whole body of constitutional law countries with an inbuilt optimism and great results. Now, let me tell you quickly four. First are the death sentence cases, where 19 cases were taken to the Supreme Court as a class action case. So remember one thing, as opposed to the developed countries' jurisprudence, which is individual-oriented, we are always class action. We don't have to certify a class action. A class action happens automatically. And in the right to food case, we had 350 million persons as part of a single lawsuit, getting free grain and subsidized grain and so on, and the right to work for people and so on. First, the death sentence cases, where 19 cases were taken to the Supreme Court. 7 o'clock in the evening, we get a telephone call from jail saying that they are getting ready to hang the prisoners. How do we know? They're cleaning the gallows, which is there in the courtyard so the prisoners can see. And they're giving them clean clothes to wear. And they're offering them a meal of chicken, which is your last meal before you're hanged. Hanging time at dawn. So 7 o'clock in the evening, we prepare a case. The Supreme Court is closed. We speak to the registrar. We go to the Supreme Court judge's house. We stand in front of his home at midnight. This is the Chief Justice's house. He has to hear the case because there's going to be a hang at 5 o'clock in the morning. He takes us in at midnight. He knows of our work. He takes us in at midnight. We're standing there in our colonial gowns and colonial bands, holding our books, and we walk in and he smiles. And I say to myself, that's a good sign. And then he says, Colin, why are you carrying books? And I say, back of my mind, we're through. We are absolutely through. And he says, sit down, have a cup of tea. And our main case was that their mercy petitions had been pending before the president for periods ranging from 6 years to about 15 years. Our argument is simple, that keeping a person on death row with that sword of the death sentence execution hanging over them, because their mercy petitions are not yet decided, is cruel, inhuman, and degrading treatment, and is akin to torture. Right? We stretch it a bit. Supreme Court accepts it. He says, how many years have they been with the mercy petitions pending? We say, sir, 6 years to 15 years. He says, please sit down, dictates the order. Then he tells his staff, call all the jail superintendents and tell them not to execute so that nobody is executed by mistake. 19 persons, including the persons accused of assassinating our Prime Minister, Rajiv Gandhi had their sentences commuted. And on final hearing a year or two later, all 19 went from death sentences to life imprisonment. Quick case, 24-hour case, immediate victory. What was the cost of that case? Maybe $100? That's it. So you see how public interest litigation works. I'll give you 2 or 3 quick cases. Yeah, I'm sorry. No, too many.
Give us one more.
Okay, I'll give you one more. Right.
Now we are really
Okay.
curious.
Okay, I'll give you the Chhattisgarh case, which is a war zone, right? Where in a war zone with the Maoists there, the government sets up a vigilante group. So they take young people, 7,000 young people, they pay them a certain amount of money, they give them automatic weapons, and they give them a policeman's badge, which means policeman's immunity. So he can kill, he can rob chickens, he can rape women, and so on. We go to the Supreme Court and say, dismantle the vigilante group supported by the state. Long story, we'll cut it short. Supreme Court in a stunning decision. If any of you all go onto the web, the Indian Supreme Court, and look at the judgment, Nandini Sundar versus State of Chhattisgarh. Extraordinary judgment of the Supreme Court of India, where they say the real terrorists are the corporations who use their muscle power to push the tribals off their lands and so on and so forth. And the last case is the Manipur case, where 1528 extrajudicial killings by the Manipur police and the Indian army in a tiny little northeastern state called Manipur comes to the Supreme Court that has never taken the Indian army to task. And the Supreme Court delivers judgment saying, whether you're in uniform or you're a civilian, you kill anyone, there'll be a complaint registered against you, there'll be investigation done, and you can be prosecuted in an ordinary civilian court, criminal court. So that's shaken the Indian military. So there are enormous things. I'm not speaking just about India, Nepal, Pakistan. I want you all to think not simply of taking cases from the developing world and prosecuting companies in Europe. That's a very good first step. But I want you to think really in terms of globalizing our human rights movement, human rights law movement. Bring the constitutional law people in so that you understand their discourse and their work and so on. They've revolutionized the system of law. Locus standi has gone. Anyone can take a case in the High Court or Supreme Court. I fought the right to food case on behalf of 350 million starving people without a single authorization. It's not possible, right? It's not possible to get authorization of starving people and illiterate people and poor people. The court encourages you to come. Individual rights are replaced by collective rights. Separation of powers is undermined, and you might think it's sacrilegious. The courts say where the executive does not protect human rights, courts will go in and step into the shoes of government and deliver almost executive-like orders directing government to do this, which people in the West say, oh my God, it's like the courts running government. And to which we say, when governments have declined and governance has come down, if the courts intervene and give you directions, that's not a bad thing in the developing countries. Financial inability that the court the courts cannot deliver judgments that have a huge financial effect on the budgets. That went in the 80s with the dictum of the court saying the court will not entertain, when it comes to the enforcement of human rights, the courts will not entertain an argument that the states have no funds. So extraordinary developments, I want you to recognize it. I want you to bring it into your European discourse and your American discourse. I want you to recognize the revolutionary work being done in different parts of the developing world and make it part of your common global human rights law conversation. And I'm sorry.
You should not be sorry. No, thank you. And I think that is a wonderful way of opening it up also to all of you for questions. I mean, we are acting in our sort of local capacities, but we do need to think globally, and we do need to connect with friends and allies around the world in order to broaden the scope of advancing both the law but also affecting change. So I'm opening this up now for questions. I mean, you have the last chance to ask questions to our extraordinary panel. So the floor is yours, guys. Please, use it. Anyone? I know it's late, but that cannot be. All right. Well, there is one from Manfred.
Wolfgang, you said before that a universal jurisdiction is not very effective. If you would look into the strategy now, would you think it is more effective to actually rely on the ICC or other international criminal tribunals, or more on the universal jurisdiction side?
Sorry for having caused this misunderstanding. What I was kind of cautious is to repeat universal jurisdiction cases in a certain way, and I think Reid made this point earlier today. You know, like going to Spain and going to Belgium and file one case after the other without really thinking of is this the right forum? So what we're trying to do is to sit down, and of course, in the best case, we sit down with domestic communities and lawyers and figure out if we go to the Supreme Court in India, or if we go to the Inter-American Court or the European Court of Human Rights, if we file a universal jurisdiction case, or if we go to the ICC, or all together. And then, I think that's the kind of exercise we have to undertake. And then we have to spell out what we expect from a certain case, because you know, one can more or less predict what is the potential of the case, and then not only reference to these human rights slogans, you know, like the ICC brings justice to the world or whatever, because then you have to see, and I totally agree, victory without success is also winning a court case, which has then a bad impact on the ground. I think we then have to, and here is when communication comes in, you know, when connection with artists, with intellectuals, with academia comes in, because what we do in the legal discourse has to be translated in the discourse of the society, in the artistic discourse. And that is something I think some of us, or in the earlier days, was not so well, and so was not so carried out so well. I think if we do this kind of cases, we have to do it in the right way. And the right way is doing it legally, you know, fully professional, but then also communicating it in the right way. And we have lots of tools. Lots of filmmakers are interested, a lot of journalists, a lot of writers, and we need them to have this kind of broader impact, to have our legal efforts embedded in this broader efforts.
Yeah, I have three questions down here.
Thank you. I'd like to ask about, well, you've mentioned declining space for lawyering, and in that relation I would like to ask you, I've sometimes almost got the impression that at least in Europe, maybe also in the Philippines, we have social movements against rights, against human rights. So in Germany we have this debate, okay, has the individual right to asylum gone too far? Is this too much of a pull factor? Don't we need a limit, like a cap? We all know, I think, about the policies of President Duterte in the Philippines, who, my understanding is that he's still hugely popular with large parts of the population. So I'd be interested in your thoughts on that and how to counter that.
I think it's whoever wants to take this one,
Yeah.
but of course we are operating in a new sort of very challenging environment, and it's not unique neither for Europe. I mean, we are seeing it through the election campaign in the US, where bigotry and hatred and xenophobia and outright racism has become commonplace. It doesn't have to be fringe movements. It's even mainstream politics, and in many places, including here in Europe. How do we operate within that context?
I have one very quick remark. First of all, movement is not always good. That's one. No, but we have to be aware of. We have to be aware of that. And the other thing is, it's defense work. It's defending standards, and sometimes we are the only ones, or we are only a few ones who defend the standards. For example, the absolute prohibition of torture. But it's very important to do this, and I think if you talk about Guantanamo, I would call that a success story, because the model Guantanamo could not be exported all over the world. And I think that is important for the moment. I mean, there are a lot of other Guantanamos in China, in Russia, in North Korea, and wherever. But as a Western model, it failed, and I think that was due to your work.
The history of the Center for Constitutional Rights is that we started in the 1960s, where there was a tremendous upsurge, and we had courts that were sympathetic. And we pioneered the notion of bringing affirmative suits to extend rights, to push rights into new areas, to expand rights. I do think we're now in a different, and Guantanamo is and we have been for some time. Guantanamo is an example where here we were trying to defend basic democratic concepts of due process in a context where people were outside of the law. And I do think it was a great success in preventing the U.S. government from taking people and putting them outside of the law. My only point was that even successes, and this is Catherine's point, even successes have a dual nature to it. And Michael felt that, which I know. And because if you're really trying to change society, when you even win a case which defends the rights that we now have, while that's a great victory, what we really are trying to do is move things forward. But maybe in this era, defending things is all we can do. But I actually don't believe that. I think even in this era, we have to be constantly striving to see how we could recognize our ideals, both through political movements and through the law.
Not to be defeatist.
I thought your two examples were quite interesting, of the Philippines and then here in the European context, because then in some ways they raise the same issue but in a very different way. And the attacks on human rights as an overarching norm or set of public values, I would even say a kind of public morality, we see at stake and undermined in the European and I would say in the American context through as a result of the shrinkage of the state, the expansion of corporate power, and no longer seeing the state as a place where public morality is defended and there's an infrastructure for enforcing it. In the United States, what's happened is a rise of religious resistance to fundamental human rights. And part of why that's been successful is that the state no longer makes a very good case for public morality. Morality is something that belongs to religion, not to the state. And so public morality could be things like equality, freedom, things like that. And the state no longer makes that case or holds those values as convincingly. The Philippines case is, of course, the flip, where you have an incredibly strong state, not a weak state as we do in the United States context, or at least on the domestic front. And so you have through the kind of tyranny of the powerful state, the evacuation of a kind of collective commitment or capacity to enforce human rights norms or public morality. So those two examples, I thought that you paired them together was quite interesting and I'll just say brilliant. Yeah.
So Simon, take the brilliance. Yeah. We have two more questions from
Yeah, I have the microphone now. I have a question to you, Colin. You mentioned earlier that we should come to India to share experiences with our legal system and our case law. And on the one hand, I feel a bit conflicted about that because I'm white and European, and on the other hand, I'm wondering how you see this in the context of a more and more nationalistic government in India that portrays foreign powers trying to take influence in India and preventing it from developing.
The reason why I want you to come to India is not just because you share your history of litigation and human rights litigation and so on. I also want the developed countries, the minds of young lawyers to open. You know, it's been clouded by a kind of Western jurisprudence that is very, it is colonial in a way, in which, in terms of certain principles that you find indestructible or basic to law. And you'll come there and you'll find that struggle and movements and the response of judges to struggles have cleared away that debris quite a bit. And in the 90s, we had jurisprudence which said we are getting out of this Anglo-Saxon system. We're getting out of this adversarial system. We're getting out of this system where rights are individualized. And we want to open our doors of our courts to those who can't, who don't have money to come to court, who are not literate, who are poverty-stricken. We want to open the doors of our courts to this. So I want you to come for a dual purpose. You have an educative role to play, but you must learn from these systems. And it must come into Europe. These ideas must come into Europe. I've heard European judges, I've been to all kinds of meetings where I've heard judges, senior judges speak with such authority on things that we have, you know, it's what we call the debris of colonial law, which we swept away many years ago, and I hear it spoken again and again. So you must come. It's like a little adventure for you. Come to these countries and see what adventure is going on in the courts, you know. And you will experience, if you're a lawyer and you're practicing, you will experience a totally different world of law and practice and open up immense possibilities for young people to be little Che Guevaras in the legal system.
So hook up with Colin and then book your tickets and spend some time with him and his center and learn also. I mean, it's not just a one-way ticket in terms of learning. There was one more question. Yeah.
I have a question concerning the current withdrawals by African states from the Rome Statute. My observation is that the global voices are like, okay, Africa wants to leave. So, but there are these 4 or 5 states that support the ICC. And some are saying that even if the 34 countries leave, there's still like 90 states that are still parties to the Rome Statute, so the ICC will still be there. But then I'm wondering if most cases are from Africa, you know, and so if Africa leaves, then, and there's also the problem of the UN Security Council's power over the ICC's investigations and prosecutions. So that's a challenge. So I'm wondering, who is talking about the alternative means of enforcing justice in Africa? Are we just afraid that they're leaving? But if we are going to focus on the victims, so what do we do about the victims who want justice in Africa? Do we also talk about the alternative means of enforcing justice in Africa, instead of just fearing that when Africans leave, the ICC might be at a disadvantage?
Okay. I have my own thoughts on that, but of course, well, I'm sure someone in the panel will go first.
Yeah, I mean, I think we commit a mistake when we talk about Africa. It's some leaders of some African states, and with a lot of criticism within that same states. For example, South Africa. It's the Zuma government. Dot. And so I think again, we come to the same point as we were before. First of all, we have this something which we have to defend. We have to defend the commitment of those states to the ICC, because it's important to maintain the standards. On the other hand, it's also important to maintain our criticism towards the ICC. And yeah, I mean, I can refer to my book right now, The Double Standards, and the discourse of you know, like this falls now down. You know, this falls now down. Since 5 or 6 years, we are criticizing not only the ICC, but the international criminal justice system, because they only go after defeated, they only go after Yugoslaves, they only go after Africans, they only go within Africa, within the African situation, they only go after one party, and that is wrong. That undermines the system, and this is why, and Reed said it in his contribution earlier today, not to stop prosecution of those parties. No, we have to continue it, because it seems that all of them are involved in crimes against humanity and war crimes, but to expand the work of the ICC. So it cannot be that in Uganda only one faction of the war is on trial. It cannot be that Colombia is still a preliminary examination, especially in that particular situation right now when the peace agreement is about to fail. They have to open a real investigation into Colombia. They have to open a real investigation into the UK Iraq torture case. And of course, they have to support domestic and regional efforts like the Hissan Habre trial, which took place in a regional court in Senegal. I think that is also something that has to be carried out.
Well, maybe just a few thoughts from myself, if I may. I think it is important when we look at international justice as such, not to look at it solemnly through the lens of the ICC. Then that gives us a very, a biased picture in terms of focus on Africa. Actually, the precursor to the ICC was the International Criminal Tribunal for the former Yugoslavia. Had there been an ICC when there was war in Europe in the former Yugoslav countries, then the Security Council would obviously not have created this special tribunal, which actually is more powerful than the ICC because it's a court of first choice. It's not a court of last resort. It didn't have to overcome the burden to prove that national jurisdictions were either unwilling or incapable. And then if we look at what the ICTY was doing in terms of issuing arrest warrants for sitting heads of government and state, ministers, chiefs of staffs, and so on, then you would get a quite different picture in terms of how many people have been subject to international justice. And I think that is somewhat missing from the debate among some African leaders that are advocating that their countries should leave the International Criminal Court. I think the other part of this discussion is also that when we talk about those African countries that are advocating leaving, and it is many, unfortunately, there are not many that have gone through this step. But when we then look at what the movement, the lawyers, the victims groups, the activists in Africa are advocating, it's very different. They actually see this court also as a court that would have been profoundly biased had it not taken the plight of African victims seriously. And in many ways it did. I have been very critical to the court in its first years. I thought the prosecutor of the court in the beginning, I mean, he took the court to places where it should not be. He acted more like a politician than a prosecutor. I think that has changed with the current prosecutor, and I think Fatou has really brought the court back to what it should be, an impartial, independent legal institution that will base its work based on facts and evidence. But I agree with everything that you said. We need to not engage in the discussion about the cases that are well deserving in Africa, but really also work on the cases that are deserving elsewhere and promote those and help them be brought forward. Yeah. Any other questions? Then I want to put a last one to all of you, because it was one that was brought up both by Reed, but also by I think, very eloquently by Miriam in her panel. And it is really the role of victims for success also of the cases. And I would say not just the success in the courtroom, but success in affecting change. And are we really good enough in building these movements around victims? Aren't we too often actually engaging in these legal battles because we consider them important, and we go forward sort of leaving the groups of people that should be part of lifting this burden, and that we should help rather in moving forward? And I'm asking you this also as international law and in the International Criminal Court and other international mechanisms are at stake. I mean, how do we advance our role in cooperating with those that this actually affect more than anything? It doesn't affect us that much. I mean, we do what we do because we consider it important. But how do we become better in hooking up with those that these cases will affect? I think you have worked a lot on this and also have galvanized, I think, a lot of passion about how to involve the groups that we represent. I mean, you've represented more people than any of us in this room through your public interest cases, but how can we learn from you on how to do that better in our midst?
The victims always remain center stage. We don't do a case because it's an exciting case. We don't do a case because we think it's an exciting proposition of law and then we don't go to hunt for clients. We don't do that at all. We look for a case where the victims are crying out for justice, like the Manipur case of 1545 disappeared persons. Then the widows of the disappeared formed a committee. They involved the NGOs. They did the fact-finding. They made their report on disappearances. We gave that to the Supreme Court. Supreme Court held in their favor and said, we want you to meet each family again. 1528 people. Meet each family and interview them and find out, because many years have passed, do they want to go ahead with the case or do they want money? So then the families, the widows of the disappeared, put an advertisement in the newspapers and have a laborious process of intervening, of interviewing each family and so on. So the victims are always center stage. They are the starters of the case, right? And when the orders come, they are the ones who monitor implementation. If you don't have the victim center stage, then it's better not to do it. Then you just leave it and let it lie for some time.
This is an area where I've changed over the course of my career. I'm a law professor, and I deal in ideas, and I deal in principles and theories. And I'd say for the first 20 years or so of my experience at the center, a lot of my work was bringing cases which involved important legal principles, important social principles, war powers, anti-intervention, human rights. But unlike Michael, I wasn't deeply involved in the people's lives who we were working with. And I think one of the things that Michael really was, one of the things he was exemplary at, where he was a really model for all of us, was really going to people, being involved with their lives, having a passion for people's experiences and people's suffering. I think I changed in the course of my work around solitary confinement, where these prisoners went out on hunger strike, and I got to know them. And I went, and I have to go every month or two to California, which is a long way away from Pittsburgh, and meet with people and talk to them. And it gave me a sense that to be a movement lawyer, to be a human rights lawyer, you really have to connect with the people who you are involved with, and share their stories, tell their stories, and, as you say, make that front and center stage in your work. So I urge you to eventually get to that or take that course and maybe learn it quicker than I did.
We teach, I'm also a law professor, as you know, and we have a class that all students have to take on interviewing clients, right? And the real aim of the course is to listen to a client's story and then convince them of what are the relevant facts of their story, because that's what the law treats as relevant. And so the law shapes the story rather than the story shaping the law. And I think what CCR has done, what all of you here have done, what Michael did so well, was have the story shape the law, and have the story push the law, and often in uncomfortable ways, rather than having law shape what the story is, which is tragically what we learn too often in law school, or what we teach in law school.
Lotte, should we end, or should I provoke a little bit at least? I mean, I think it's easy to say, yes, the victims have to be involved, but then I would say, please don't use the word victims, use the word survivors or affected persons and groups of persons, because victim is heavily questioned by many groups whom you would consider as victims. That's the first remark. The second remark is, don't make a fetish out of victims. And also because of the victims, survivors, affected communities. Because we are defending the one problem with this, fetish of victims and representing victims is that we are reduced to represent certain individuals and certain groups, whereas we are defending universal interest. I don't want to live in a society where people are tortured. I don't want to live in a society where companies go outside of my country and exploit people. I don't want to live in that, and that's my own interest, and that's the interest of the society. And so I would, of course, you have to involve. I mean, you cannot litigate a case of a village in Peru affected by a Swiss mining company without involving the villagers. That's very clear. You cannot, and we see it in our migration litigation. You cannot litigate cases without considering the possible damages of the people who are. But we have to make very, very clear, and I'm missing that. We have to make very clear that not we are defending particular interest, but we are defending universal jurisdiction, and those who are against us are, they are standing for particular interest of the elites, of the corporations, etc.
Right. I mean, I don't think in that sense it's an either or. It needs to be both. But there has been a certain tendency to leave those most affected by the violations and the abuse sort of as a sideshow. And that leaves me to the question that was raised also on the International Criminal Court. I think one thing that is completely missing in the narrative of the debate that we are having, I mean, when Bashir was not arrested in South Africa and was helped by the government to leave, that was the case that Zuma was being challenged with at home now before the Constitutional Court. The narrative is about the ICC as a big institution being against an African leader and being helped by another fellow in Africa. But what was completely missing in the story was, why was this arrest warrant out there? Where was the stories of the Darfurian women who had been raped, the people who had seen their villages bombed, the people who are still living as refugees or internally displaced as a result of absolutely atrocious crimes? That was missing. And I do think that that is where everything needs to come together, and we cannot have these discussions without bringing in that narrative and have a sincere debate about the issues. I think this was sort of a fitting end, actually, to our panel. And I must say that I think this day would have been one that our friend and former colleague Michael would have, and now I'm getting emotional, would have been really, really happy about. I mean, this is exactly the forum that Michael would have gone back to the dinner that I'm going to tell you about just in a few minutes, and he would have sort of worked the floor and told everybody, I was so happy that I heard this from you, and this was great, and now we do this, and now we do this. I mean, Michael had an extraordinary moral compass that we can all learn from, and I think this day had showed that we have, and that we appreciated him as a colleague with ideas, as a colleague that we would fight because we wouldn't agree with all his ideas, and that was how it should be. Michael was an extraordinary, genuine man. He was saying what he was doing, and he was doing what he was saying. There was no hidden agenda at all. And I take so much pride in having worked with and known Michael, and I'm thankful for having had that opportunity. I want to thank all of you for coming. It has been a great day. I learned so much. I want to thank the European Center for Constitutional and Human Rights. I want to thank the Center for Constitutional Right, and I really want to thank Berta also for once again making it happen and making us all having these conversations and these discussions together. We will have the opportunity to be together for a couple of days, so there will be hopefully many sidebars with many great ideas, many ideas that will then lead to action. It is inspiring to be with all of you. I have been asked just to give you a piece of sort of very practical information. I think Wolfgang already said this, but there will be a dinner following from this event. It will be at the place Max and Moritz, which should only be 2 minutes walk. So all you have to do is to follow someone who knows where they're going,
and not do like I'm doing, just following someone who looks like they know. So make sure they do and that you follow them. And then we all meet up there at 7 o'clock. So you have a time to have sidebars here while you're still here for about 20 minutes. And then I think we will start walking. But thank you for coming, and what a wonderful day it has been. Thank you.